Okay, in this video, I want to take a look at without prejudice communications in disputes, and in particular in legal proceedings or threatened legal proceedings or legal proceedings, as I say, that are threatened and that there may be a dispute. You may have received a letter and been made an offer on a without prejudice basis. And you may also, if you were leaving a job and there was a settlement agreement or an exit package going to be put on the table, you may have been offered an agreement on without prejudice subject to contract basis. What is what does this actually mean? For the ordinary person, it might be difficult to understand the difference between without prejudice correspondence and ordinary correspondence. First thing to be said, though, that in relation to without prejudice communication is that communication involves both written and oral communication. So you may have a chat with somebody off the record, and it should be off the record, or you may enter into without prejudice correspondence. Either way, the without prejudice rule should apply, but you need to be careful. So, what does without prejudice communications actually mean? What is the without prejudice rule? Let's take a look. The without prejudice rule or principle is one which states that statements made orally or in writing are marked without prejudice with a view to settling a dispute will normally not be admissible in evidence against the party who makes a statement or writes the letter. So essentially, somebody is going to write a letter to try to compromise a dispute. There will probably be some form of offer or some form of compromise from a previously stated position, and this will be made on a without prejudice basis. It's widely regarded as a good thing that parties to a dispute will attempt to settle their differences rather than going to court on every occasion. Clearly, there's costs involved in going to court, and the more that disputes between people, between companies, between parties can be settled without the need to go to court and the expense involved, the better. So that's why this general principle of being able to engage in without correspondence or off the record chats or conversations with other parties is generally accepted on public policy grounds. It's a good thing. The effect of without prejudice then, any concession offered in a without prejudice letter cannot be referred to later on if the matter is not settled and it goes ahead to court. So, any offer made in a without prejudice letter cannot be open to the court. The effective or the label then, just because there's a principle of without prejudice and just because it's accepted that it's a good thing, doesn't mean that all correspondence that's marked with the without prejudice label is going to be genuinely without prejudice correspondence and not opened to a court or to a dispute resolution body. So using the label will not give any protection if the correspondence is not a genuine attempt to settle the dispute. Another way to think of without prejudice correspondence, which will have protection later on, is without prejudice correspondence, which makes some type of concession, is generally going to get the benefit of the principle. If it does not make a concession or if it does not try to resolve a dispute, then it may not be have the benefit or protection of the without prejudice rule. Open correspondence then is the opposite of without prejudice correspondence. An open correspondence or an open letter, an open offer may be made in a litigation situation, in a legal dispute, and it may be made for tactical reasons. Exceptions to the without prejudice rule, like everything else in law, there's a rule and then there's exceptions. So there are a number of various exceptions which have been recognized by the courts down through the years. There's four of them there on the screen, as you can see. For example, when the communications demonstrate the fact of a concluded settlement agreement. So if there's a concluded settlement agreement and one of the parties then looks to resile from that agreement, then the without prejudice correspondence can be open to the court to prove that there was in fact a settlement agreement agreed and signed by both parties. It may also be open to a court to look at without prejudice correspondence in order to interpret a settlement agreement. There may be settlement agreement. Both parties may have signed it. However, there may be a dispute about a particular term or a particular effect of a condition in the agreement. Also, without prejudice correspondence may be open to court if it's to provide evidence that a settlement agreement should be set aside on the basis of fraud or misrepresentation. So if one of the parties engages in fraudulent conduct or makes fraudulent misrepresentations or warranties or assertions, then if the other party wants to have the agreement set aside, they can rely on opening the without prejudice correspondence to the court. Also, where the communication is evidence of perjury or blackmail or other serious impropriety, a without prejudice letter or correspondence can be opened to the court. Employment-related settlements or exit deals, these typically are negotiated on a without prejudice basis in the first instance. So the communication will be from the employer to the employee, and the employer will be asking the employee to encourage the employee to get legal advice. So that's it in relation to without prejudice communications and so on. My contact details are there on the screen. I hope you find this video useful. If you do, give it a thumbs up down below, and you might be interested in subscribing to my YouTube channel. I have a lot of videos on my YouTube channel about all aspects of Irish law, including employment, property, family law, litigation, all sorts of stuff. Thanks.